Thou shalt not kill, the sixth commandment that God has given us. Unfortunately, many in our society do not adhere to this, and we are faced with the increase in murders every year. What should be the punishment? The Privy Council has said only the worst of the worst can receive the death penalty. Are we pleased with that as Bahamians? If not, where can we go? What remedies are available? These questions and more will be answered on The Legal Brief. I'm your host, Ramona Farquharson, and you're watching ZNS TV 13. Thou shalt not kill, the sixth commandment that the Lord gave Moses, and by extension, all of mankind. Unfortunately, many of us do not adhere to that commandment, and as a result, we have numerous sections in our laws that speak to murder, also the penalty of murder. In this episode, we will explore this area. We will answer many of your questions. And joining me is none other than the only person who has been president of the Bahamas Bar Association, Attorney General, Chief Justice, as well as President of the Court of Appeal. We are honored to have with us Sir Michael Barnett. Thank you, sir, for joining us.
Thank you for inviting me.
Yes, let's get right into it. Murder. You certainly would know that our people are up in arms over this topic for a plethora of reasons. But firstly, let's look at what is in fact murder, looking at our penal code at section 290.
Well, the section's very clear. It says, whoever intentionally causes the death of another person by any unlawful harm shall be guilty of murder.
Yes.
So murder requires an intention to kill.
Yes. So that's the mens rea, the mindset we have to
and
have.
it has to be done by some unlawful harm.
Yes, the act. For many of our law students listening, the act is raised. That act must be there. And so let's say, for instance, as well, someone inflicts harm or whatever the circumstances may be, but they don't intend to kill. Sometimes we have where there may be an argument that they may have family, relatives, whatever case may be. How do we then determine if in fact that is murder?
Well, in those circumstances, the offense is probably going to be manslaughter and not murder, which attracts a lower penalty than murder does. And there are many instances where homicides take place, where there is not the intention to kill, or for whatever reason, the person is not guilty of murder, but guilty of manslaughter.
Yes.
And that we have many cases where the courts struggle with what is the proper sanction or the proper punishment to impose on a person guilty of manslaughter as opposed to a person guilty of murder.
Yes. So now so that's very clear for persons listening in. But now let's zoom back to murder itself. And so the penalty, let's look at the penalty. We've defined what it is. The penalty for many persons, you would have them say, it's on the books. I hear it often, death, the death penalty, it's on the books. Why not have it enforced? But there have been certain amendments since, I think, 2011 with respect to the penalty. And so let's get into that.
I think it's useful to look at the history of the law's approach to the offense of murder.
Okay.
There was a period of time where it was felt that every person who was convicted of murder had to suffer death.
Death, right.
Capital punishment. There was no issue. Murder, death. And the courts revisited that issue. And they made the determination that the mandatory imposition of the death penalty was unconstitutional, and that you should construe the provision as saying you are liable to the punishment of death, but you're not compelled. The judge is not compelled, is not obliged to impose the death penalty.
So it's not a mandatory sentence.
That wasn't always the law. I mean, the law was, or the approach was, once murder, death. And once you accepted, or once the courts looked and accepted that the mandatory imposition of the death penalty was unconstitutional, they then looked at the issue as to in what circumstances is it appropriate to impose the death sentence.
Right.
And that has been the struggle up to today's date.
Right.
As to when would be the proper circumstances.
When almost like the court grapples with striking the right balance.
Yeah. And with the jurisprudence developed was that the death penalty really ought to be the last option. That you should not impose the sanction of the death penalty unless there was no other more appropriate sentence that you could impose.
So that's very interesting there, because I think people need to understand that. So is it then that the law is saying not so much, we hear this phrase, the worst of the worst, that it's the worst possible murder or heinous act, but rather looking more at the circumstances of the defendant?
Not in fact, to the contrary.
Okay.
The court said there's a twofold test. Mm-hmm. Firstly, the actual murder must be, and they've used the expression, the worst of the worst, or the rarest of the rarest. And unless it falls within that category, it ought not to attract the death penalty. Mm-hmm. But they go further. The courts have said, even where it is the worst of the worst, you should not impose a death penalty unless you are satisfied that there is no possible chance, or there's no likelihood, or no realistic chance that this person is going to be rehabilitated, to be reformed. And I think that's what was said in the decision in Trimmingham.
Yes.
Trimmingham, which forms the genesis of most of the jurisprudence.
Yes.
It'd be helpful, perhaps, if I were to describe what happened in Trimmingham.
Yes, go ahead.
In that case, which came out of St. Vincent and the Grenadines, the defendant was convicted of murder of a deceased who was 68 years old. Those rather brutal circumstances. The defendant, who had been carrying a gun, had gone to the land where the deceased kept his goats. And he had made the deceased get on the ground, struck him in the stomach, causing him to fall into a ditch. He then cut his throat with a cutlass, and then he removed the fellow's trousers, cut off his head, and put the head in the trousers, and then he slashed the defendant's or deceased's stomach. It's really gruesome.
Really gruesome.
And the death penalty was in fact imposed.
Right.
It was interesting what the Privy Council said.
Before we get there, we're going to stick a pin, because this is very, very interesting. You're watching The Legal Brief on ZNES TV 13. Welcome back. You're watching The Legal Brief. So, Michael, just before the break, you were taking us through the case of Trimmingham, in particular, the decision by the Privy Council.
Yes, I think because that's the genesis, and I believe that sets out what the Privy Council has said should be the approach of judges in dealing with the question of the death penalty. And it'll be helpful to read this to the listeners if I were to read what the Privy Council actually said. It said, judges in the Caribbean courts have in the past few years set out the approach which a sentencing judge should follow in a case where the imposition of the death penalty or the death sentence is discretionary. It can be expressed in two basic principles. The first has been expressed in several different formulations, but they all carry the same message, that the death penalty should be imposed only in cases which, on the facts of the offense, are the most extreme and exceptional. Open brackets, the worst of the worst, or the rarest of the rare. In considering whether a particular case falls into that category, the judge should, of course, compare it with other murder cases and not with ordinary civilized behavior. The second principle is that there must be no reasonable prospect of reform of the offender, and that the object of punishment could not be achieved by any means other than the ultimate sentence of death. The character of the offender and any other relevant circumstances are to be taken into account insofar as they may operate in favor of mitigation and are not to weigh in the scales against it. Before it imposes a sentence of death, the court must properly satisfy itself that these two criteria have been fulfilled. So, surprisingly, in Trimmingham, in the circumstances where the accused cut off the head of the victim, sliced the throat, cut his stomach, the courts were not satisfied that that fell within the category of the worst of the worst.
The rarest
or
of
the
the
rarest
rarest
of the rarest. So it's a very high threshold.
So then the question is, and I know many persons who are watching this are absolutely screaming now at this television screen. So Michael, where does that leave us then? Because we are seeing in the courts that there seems to be a shying away. Not the prosecution, they're not requesting the death penalty.
Well, the Bahamas Court of Appeal in the Max Tito case did express some view as to the kind of circumstances where the death penalty may be appropriate. It said, in our view, the worst cases of murder which may call for the imposition of the condign punishment which the law allows would be those in which the murder is carefully planned, carried out in furtherance of another crime, such as armed robbery, rape, drug smuggling, human smuggling, drug wars, gang enforcement policies, kidnapping, preventing witnesses from testifying, serial killers, as well as the killing of innocents for the gratification of the base desires of men. That was what the Bahamas Court of Appeal said. And I think that sense was not dissented from in the Privy Council's decision in Max.
So you feel that still holds
and I think
sway today?
It has been given statutory effect.
Yes, it has.
By the 2011 amendment to the Criminal Code, where the courts or the Parliament has set out the circumstances in which they say the death penalty is on the table for consideration by a judge as a punishment. And that section, that amendment to the Penal Code sets out the circumstances which reflects
we have section 291
what the Court of Appeal said in Max Otito. Perhaps you could read to the members of the public.
Well, it's certainly there at paragraph. They inserted a section 2, and then they go through in that section in section 2 from paragraph A all the way to F, and very much it encapsulates.
Yeah, because it's helpful to set it out. Would it? The Parliament itself says that the death, any murder committed by a person in the course of or in furtherance of a robbery, a rape, kidnapping, terrorism, and other felonies,
and any other
the murder of one or more persons, any murder committed by a person who before murder had been previously convicted of another murder, any murder committed pursuant to an arrangement where money or anything of value, like for example contract killings. The statute sets out those examples in which the death penalty is permitted by the law, is a sanction that the law empowers the judge to impose.
However, we are certainly when it comes to murders that have occurred in the course of furtherance of robbery, rape, kidnapping, that's very common, or it's allegedly very common.
Yes.
But we are not seeing where the request is being made for the death penalty. And I'm just wondering if you have any thoughts as to why our prosecutors or the Attorney General's office or DPP's office is shying away.
I don't know the answer to that question. But bear in mind, the mere fact that the murder was committed in the circumstances,
in the furtherance of those
set out in the statute,
yes,
doesn't mean that the judge is obliged to impose the death penalty.
Not at all.
No. So there's still a residual discretion, and you still have to fall within the two principles set out in Trimmingham. For example, the Court of Appeal has on record said that simply because it's a contract killing, that does not automatically result in the death penalty. That may be surprising to people.
Yes.
But the Court of Appeal, I think it was Auntie Clark, or I can't remember which specific case, specifically said that the mere fact that something is a contract killing doesn't necessarily mean that it falls within the worst of the worst or the rarest of the rarest.
When we come back after the break, I really want we're going to pick your brain on this. I know that there's no exact formula, but we're hearing these terms. Are they just unattainable, obscure, bleak, and we're never going to get there? I think certainly our viewers and everyone we would want to know. You're watching The Legal Brief on ZNS TV 13. Welcome back. So, Michael, we're getting now to the meat and the potatoes of this discussion. This term, the worst of the worst, the rarest of the rarest, is it attainable? And if it's not, is that fair? Just as we ought not to have a mandatory sentence of death, persons can accept that for the most part, and there's certain criteria that are placed there that ought to be fulfilled. Is it fair, however, to have this benchmark, whereas once it goes to that final place, we're never going to reach that? Is it really fair to us as a people? And if it's not attainable, should it be on the books?
Those are very powerful questions, Ramona. And I think, like most judges, we agonize as to when does it fall within that category. I can see why someone would suggest that the circumstances of the Trimmingham case ought really to have fallen within the worst of the worst, where the slice his throat, cut off his head, slit his stomach. That's rather gruesome.
Yes.
And
I would say even Max Tito with the Canova matter.
Well, I think Max Tito, I understand it. If I remember what the Privy Council, if I can speak what the Privy Council said in Max Tito, as to why they didn't agree with the death penalty. Maybe I could help you.
But just so the persons know that in the early hours on the 2nd of May, 2002, her body was battered and bruised, her skull was crushed. There was also evidence that her body had been burnt after death. And so, and this was a young woman.
Yeah, but this is what the Privy Council said in Max Tito. Epithets such as the worst of the worst and the rarest of the rare can give rise to conceptual difficulties as to which cases will qualify. Murder is always a heinous crime. But it is clear that a death sentence, the ultimate and final sentence, must be reserved for the wholly exceptional category of cases within the most serious cases of that offense. Whatever the worst of the worst and the rarest of the rare may mean, the board is satisfied that this case does not come within that wholly exceptional category. This was a dreadful crime. A young life was extinguished in brutal circumstances. But it is not a case that can be placed alongside the most horrific murders of which, sadly, human beings are capable. There is no warrant for believing that this was planned, nor is there any unmistakable evidence that it was accompanied by unusual violence beyond that required to effect Miss Canova's death. There certainly appears to have been sexual contact, spermatozoa having been found on a vagina swab. But there is no clear indication that she was the victim of a rape. This was, in short, an appalling murder, but not one which warrants the most condign punishment of death. That's what the Privy Council said about Max Tito. So you and I may differ with the decision of the Privy Council, and you may say that the bar is set unrealistically high.
Yes.
And we just have to struggle to see where
So would you
where it fits in the scale.
So would you say, because crime is out of control for any right-thinking citizen, it's out of, and in particular, the rate of murder or homicide in our country.
I don't want you. Well, let's go into the propriety of the death penalty. But I'm not persuaded that the death penalty is a deterrence.
You're not?
No, not at all. Not at all. I don't think the evidence and the statistics and the studies show that it is.
Statistics done here.
I think I need to put on the table.
Yes.
Whilst I'm a firm believer in upholding the law, I'm not personally a supporter of the death penalty.
But from where you sat, I mean,
the law, you're sworn.
You will carry it out.
You're sworn to uphold the law.
Yes.
And therefore, you will do what the law tells you to
and
do.
I think you accept that.
That's your judicial oath. Your judicial oath is to enforce the law.
And of course, put your personal feelings aside. Yeah. It's not about that. And I believe that you would accept, for the most part, that you may be in the minority in the Bahamas, by far in the minority. I mean, person. So
I always tell the story. Many people who are old enough to remember that my father wrote a letter to the editor complaining about my opposition to the death penalty, because my father was a very strong supporter of the death penalty. At least he was at that time. And he wrote a letter publicly disagreeing with me, and actually me and Fred Mitchell, on our opposition to the death penalty. And he said quite candidly in the letter to the editor that Fred and I were talking nonsense.
That's a good tidbit to know. But where does that leave us? And certainly we need to hear maybe your thoughts or recommendation. Putting aside your personal view, it is here, should we shy away, or should the prosecution not still seek? Let's just keep pushing and testing until the decision is made?
I think you have no choice. I think the society has to find, if it decides it's going to keep the death penalty, the courts will have to determine when it ought to be applied. And because it is such an emotive topic, it requires sober consideration. And I'm not naive to not recognize that the jurisprudence that has come out of the Privy Council is influenced by the heavy trend of Western society against the imposition of the death penalty. Yes. And we ought to be aware that many countries have, in fact, abolished the death penalty. And I have no doubt that some of the jurisprudence that has come out of the Privy Council is influenced by
their socialization. Yes. Yeah. However, we don't have the same.
Well, I'm not sure how.
In many respects.
Yeah.
We're not
I hear that, and I don't know the answer, to be honest with you. But I'm not always persuaded that our societies are that different. I believe even the jurisprudence of the Caribbean will agree that the death penalty is the ultimate sanction and should only be imposed in very, very, very limited circumstances. Where there may be a difference is, what are those circumstances?
Yes.
And you will have courts disagreeing, and the more heinous a crime, there is going to be the pressure or the view that the only sanction that you could do is the death penalty. Because remember, the test that the courts and the Privy Council have articulated is not only must it be the worst of the worst or the rarest of the rare,
But
the second principle
yes,
is that you have to be satisfied that there's no hope of rehabilitation, reform. And they say you have to have evidence that will enable you to make that calculation, which is a difficult thing, because if you're a believer, everybody is capable of being redeemed and being rehabilitated,
Particularly, and it's so interesting, particularly in our Christian society. I mean, people can have that Damascus experience and become a saint. Well, yes, but
thief was on the cross.
Yes,
and he was able to be redeemed,
make it into paradise. So we're gonna explore that and possible reforms, if any, to this area.
Yeah.
Yes, when we return. Thank you for watching The Legal Brief. We'll be right back. Welcome back. You're watching The Legal Brief, and we're discussing murder and the penalty of murder. And during the break, I'm just here picking the brain of someone I revere, Sir Michael, and putting to him, I think he may be regretting coming on this show right now, but he's in the hot seat, so to speak. Sir Michael, we are bound by the rulings of the Privy Council. That's our framework. Fortunately, you're no longer sitting. What do we do? The people, our people, for the most part, are exhausted. We do not wish to reach extreme levels of depravity, where we're talking about the worst of the worst of all murders in a region or wherever in the world, in order to impose the death penalty. We, for the most part, people wish to see that take place. Tell us, how can that happen?
I want to make a few points. We are clearly bound by the decisions of the Privy Council. And it may very well be that the Privy Council will, over time, modify the jurisprudence. I'm not persuaded that if we changed the ultimate Court of Appeal from the Privy Council to a different court, say, for example, the Caribbean Court of Justice, I'm not sure the jurisprudence is going to be much different. We are very much influenced by international norms as to reasonableness and what is inhumane treatment,
human rights
issues. And although we have not, like many other countries, have abolished the death penalty, I'm not sure that the jurisprudence, that it should only be imposed, being the ultimate sanction in very, very limited circumstances. I think that jurisprudence is not likely to change wherever we go. It's not mandatory. It's going to be discretionary. And the circumstances should be limited to really extreme,
but it should happen.
Extreme circumstances. And we have to also be sensitive to the concept, the second limb, about rehabilitation. For example, we'll give you some examples. Let's assume that one of those murders was perpetrated by a young man, 18, 19, 20, 21. Is his life such that we believe that there's no possibility of reform and that he should be executed by the state because of what he did in his youth? I don't know. I don't know. I don't know the answer, but there's certainly something that has to be considered. And there may be circumstances, and I can think of a few, where the courts may regard the circumstances as being sufficiently outrageous to warrant the death penalty.
And to deem that that person, if you can commit such a heinous crime.
Or because of his antecedents. It may very well be that, if a person has a history. And he's 30, 40, and he has a plethora of very violent acts in his history, that there may be evidence which the court will say, well, the only thing, the ultimate sanction or the only punishment I can put on him or her is the sanction of death. But judges will inevitably struggle with this.
Yes.
Because the circumstances vary with human life.
Yes.
Human behavior is
but should we stop making the request?
Well, no, I
should we continue to push and put it on the table?
That's the judge's task. The judges in whom the law has imposed that discretion the judge has to wear it.
Well, I think first of all, the DPP's office has to make the request.
Yeah, I know.
Have to make the request.
The making of the request is neither here. Well,
and then
that's only the first step.
The first step, and then we get into the exercise.
At the end of the day, it's the discretion of the judge and the courts. The DPP, even if he makes the request, it's not the DPP's call. And they can make the requests if they wish on every murder.
I'm just saying because we're not seeing much requests being made.
They look at the jurisprudence.
Mm-hmm.
They look at the
and they're shying away.
They look at the jurisprudence.
Yes.
The jurisprudence is there. If indeed the court says that a contract killing doesn't meet the threshold test, well, they're not going to ask for the death penalty in a case of a contract killing. There's no point because the courts have already said that. So they look at the circumstances of their case, and then they look at what there were previous cases in which the courts have opined.
And so is it that...
Therefore, they're not going to ask for the death penalty in a case with circumstances similar to where the courts have already rejected the death penalty as the appropriate sanction.
So are we therefore going to, or are we now in a situation where, even though since 2011, well, I mean, earlier than that, we said was death. 2011, we made certain adjustments to the penal code. Is it therefore going to just be something that's just there, window dressing?
No.
That persons are, because are we just never going to see this?
I don't know you. I don't know the answer to that, but I don't know that you could say that because the judges take their job seriously. They're bound by the law. And there may be circumstances which appear before them in which it for them fits both categories, both principles. Unless, and that nobody's going to say today, there's never going to be a case in which those two principles will not be met. That is the worst of the worst, and there's no possibility of reform. Man, no, if you want to change the law and say that should not be the law, I don't know that anybody can argue that that shouldn't be the law. The question is, what kind of cases fall within the
how do we get there?
And I don't know, because we don't know what's the future going to hold. We don't know what kind of cases are going to occur. But there may be cases in which it is appropriate to impose the death penalty.
After the break, in our last segment, I want us to look at possible reforms, and I don't know, maybe we should approach this differently, a different exercise, or maybe add something to it whereby when it does go to that final place that they may feel or be more persuaded to implement the death penalty. You're watching The Legal Brief. I'm your host, Ramona Farquharson. Welcome back. You're watching The Legal Brief. I'm your host, Ramona Farquharson, and joining me is Sir Michael Barnett. Our final segment, we're just discussing, or I was just saying to you, Sir Michael, there's a feeling that something has got to give. Something's got to break. If it is that we're not going to reach the bar, the worst of the worst, the rarest of the rarest, because even if we reach that, we then have to consider the rehabilitative state of the person that's committed this heinous act. And I guess our Christian background is such, it's hard to grapple that no one can be redeemed. So what do we do to help to curb this, this out of control situation? I pose to you, should we go back to the cat o' nine tails of flogging? I mean, and you said no right away, but why?
There's a decision of the Privy Council in which is Prince Pinder, I think it is, in which everybody said that flogging fell within the definition of cruel and inhumane treatment. Prince Pinder. No, that's not me. Prince Pinder. In fact, it's a very fascinating decision.
Do you agree with that?
Oh, absolutely.
You do?
Oh, yeah. It is a cruel, and I don't think anybody has suggested that it is not cruel and inhumane.
But isn't it cruel to kill?
Yeah, that is
in this fashion, to rape my mother, my sister, a 12-year-old girl, kidnapped in the bushes? You're behaving like an animal. How is it that, are we that civilized, or thinking that we shouldn't the punishment meet the person where they're at? I mean,
do you believe that there should be a fundamental human right that a person should not be subjected to cruel and inhumane treatment? Do you believe that? Because once you believe that, then you have to give effect to it. And that's part of our Constitution. And indeed, in Pender, it was common ground that it fell within the definition of cruel and inhumane treatment. The only reason it was sustained was because they said it was part of the law of the Bahamas prior to independence, and therefore not unconstitutional because it was saved by the saving clause. But everybody agreed that that was the case.
But then again,
but if we have a constitution, and if we believe that we have these fundamental rights and freedoms, then you have to give effect to it. And people don't realize that in fact, at that time, flogging in corporal punishment was only available for crimes against property. You couldn't get flogged for rape. It was when you took the property of somebody that you were able or you were liable to being flogged.
And so,
so let me finish. So you got to be, either you accept the proposition that there is a right, a fundamental right against cruel and inhumane treatment. And if you accept that flogging is cruel and inhumane, then I don't see how you could maintain that it should still be the laws of the Bahamas. Okay, now you asked me the other question. What should we do? I don't know the answer. I really don't know the answer. I don't think we can ignore the fact that many countries have abolished the death penalty. And we need to study those societies to see what impact the abolition has had on the crime rate. Is, in fact, the death penalty a deterrent?
Or also, yes.
Is the death penalty a deterrent? Or is this just vengeance by the society? I don't know. I don't know the answer. Whether do we want to go to the circumstances whereby a person can be on death row for 10, 15 years and be executed after 10, 15 years, as happens in the United States of America? Do we want to reach that stage? The Privy Council says it is cruel and inhumane to execute somebody who has been on death row for 5 years. Is that not reasonable? So then if you're going to say, if we got to say we need to execute them within 5 years, what about the due processes of the courts to have this matter properly adjudicated within the time frame? Putting the resources into the courts, putting the resources in the police, and reforming our system so that these things can be adjudicated within 5 or 6 years.
I think, Sir Michael, and to the question you posed earlier, I think everybody would agree that no one should be subjected to cruel and inhumane treatment. However, not everybody would agree with you that flogging falls under that category. We have to bear in mind that we've socialized differently from many persons, and unfortunately, the ultimate court. There's a difference in socialization because we spank. In many of those countries, they don't spank. They don't even spank their children. It's as simple as that. So our perception with respect to a spanking or flogging is very different. I'm just saying it cannot still be that on 21/7, we're experiencing such a high rate.
With all due respect, you cannot compare spanking a child.
No, I'm just saying that the mindset. I'm just saying the socialization. Yes,
with flogging.
No. I'm not comparing that.
Secondly,
I'm not comparing.
Secondly, our societies, this is my own view, our societies are not that radically different. I'm not persuaded that our societies.
I studied in England. I think that we have a lot of differences.
No, we have a lot in common. We share a lot of the same values. We share the same. We have very similar values.
I don't know, Sir Michael, if
There's
that is...
certain norms that are universal.
I don't know. I mean, first of all, I wouldn't... We're very much, well, people may say no, but I think that our Christian and religious grounding is very strong here, as opposed to over the pond. It's not... I don't believe that
Well,
and I think that's very fundamental in and of itself, and that speaks to a lot of difference. I would think that they're more cosmopolitan in their approach and views.
I'm not sure that I agree surely with that.
Okay.
If you look at the attendance of church in the Bahamas today as it was 20, 30 years ago,
Or even pre-COVID. Yes.
it's not the same.
No.
So this concept about we being a Christian and religious society, sometimes I believe we pretend to have a society that is not really there today. I don't know that.
And so does that mean
I don't know there's a society that we have today, or what's the same as it was.
or what we perceive?
What would you say? It's the same as it was 20, 30, 40 years ago. Certainly not the way in which our parents were.
But does that mean then that we...
What I'm getting at is that you use the example that you think we're more Christian than some of the...
Or certainly follow more Christian principles like that.
Yes. That is what I'm saying.
Yes.
I'm saying to you, one should study it, but I'm not persuaded that it is that different. And certainly, I don't know that the society of the Bahamas today is similar to the society of the Bahamas 50, 60, 70 years ago, or certainly not the society that our parents grew up in.
Maybe that speaks to why we have such an increase in crime.
Yeah, but
Yes.
I don't know that the answer to that is the death penalty. And maybe the answer to that is some more fundamental things about the society, the family life, and how we raise our children, how we teach them, how we inculcate values.
To respect one another.
I think
Yes.
that has a lot to do with where we are at today
Yes.
than laws and courts.
Yes.
And I don't know that we ought to abandon the fundamental rights and freedoms that exist in our society.
Interesting. You've listened, you've heard us. We've certainly explored and laid out for you what the law is, what is murder, what is presently the penalty within our laws. Sir Michael Barnett has a particular view, a very strong view with respect to the death penalty. However, ultimately, I think we all agree that if it is there, it ought to be adhered to, it ought to be carried out. Can that be done given what the present jurisprudence is? Again, we'll determine. But ultimately, we'd say and hope that more of our people would adhere to that sixth commandment, thou shalt not kill. Thank you for joining us. I'm your host, Ramona Farquharson, and you've been watching The Legal Brief.